Hello, everyone. Checking to see, I think we're live. Is that correct? I think we're good to get started. Good morning, everyone. Thank you for joining us today. I'm Tash Alexander, Director in Region 6 with Alberta Grains, and a farmer from Brownville, Alberta. I'm pleased to be your moderator today for this webinar. I want to start by acknowledging Alberta Grains partners on this webinar and the project that we will be discussing here today. A big thank you to SaskWheat, SaskBarley, the Agriculture Producer Association of Saskatchewan, or APAS, who I know all have farmer and staff members of the organizations joining in on the webinar today. We are very pleased with the attendance today. I know we have over 60 farmers and other industry participants joining us from all across the prairies. So welcome to you all. On behalf of Alberta Grains and our partners, I want to thank you for your interest in taking the time to attend today. I would encourage you all to introduce yourselves in the chat box and tell us where you're watching us from. You can do this by choosing all panelists and attendees in the two sections. Don't be shy, and please feel free to use the chat function throughout the webinar to chat with one another. However, if you have questions, please use the Q&A button located on the bottom of the screen. The question and answer function helps us better moderate the questions and allows you as participants to ask your own questions, and also you can talk about questions that are already asked that you would like to hear answered. The last third of the webinar, we are going to save time and dedicate to questions. But as I mentioned, the Q&A function is available throughout the webinar. I will be posing questions to our speakers today directly from questions you propose. We will do our best to get to all the questions, but please don't wait to ask your questions. Put them in as you think of them. Now, before I introduce our speakers today, I wanted to provide some brief background to set the stage for how we got here today, discussing grain delivery declarations. In March 2020, the passing of the Canada-United States-Mexico Agreement Implementation Act, also known as CUSMA for the new NAFTA, resulted in new mandatory annual producer variety declarations for farmers in accordance with the Canada Grain Act. While farmers were already familiar with commercial declarations from grain handling companies, this change was the first statutory requirement for farmers and come into effect on August 1st, 2020. The Canadian Grain Commission, following consultation with grain companies, authorized the use of a combined declaration for grain buyers, with both statutory and commercial declarations being agreed with one signature from the farmer. This format being used by most major grain handling companies. This is the format that is being used by most of the major grain handling companies today. Farmers in Alberta Grains and our partner organizations have expressed concerns that the private industry grain declarations have potential to exclude farmers, liability, or issues that occur after the grain has left the farmer's control. Further questions arose about the combination of the commercial and statutory declarations under one signature, their differing legal status and potentially differing obligations, creating further uncertainty regarding their liability. Alberta Grains Board of Directors directed staff to look into this issue, partnering with like-minded organizations. Together with SaskBarley and APAS, we launched a request for proposals process to seek a legal review to answer these questions at hand. The expansion of the statutory requirements to be included in a singular grain declaration as the liability for farmers increase, as farmers' ability to negotiate on the commercial portion of the declaration decrease, and what recourse or advice may be available for producers. Within that context, D'arcy and Deacon LLP was chosen out of Manitoba to conduct a legal review and seek to answer these questions. Today, we have representatives of their organization joining us to discuss their legal opinion, insights, and recommendations, and providing considerations for farmers. It's my pleasure now to introduce Don Peary, John C. Stewart, and Samantha Leetold, who have worked on this project and will take us through the agenda. Don Peary is a partner at the law firm of D'arcy and Deacon and practices in the areas of corporate and commercial law. With expertise in commercial real estate, secured financing, corporate organizations, securities law, and commercial contract law. Don graduated from the University of Manitoba with a bachelor's degree in science and law, and he was called to the bar in Manitoba in 2002. His work since then primarily in private practice, with brief stints in-house with government and with a large publicly traded company. Don has been a member of the board of numerous not-for-profit organizations, including Volunteer Manitoba and the Kidney Foundation of Canada. Don provides legal services through Don A.J. Peary Law Corporation. John C. Stewart joined D'arcy and Deacon LLP in 1998. John was born in Winnipeg, where he received a Bachelor of Science in Agriculture from the University of Manitoba. He graduated with a law degree in 1992, and he was called to the Manitoba Bar in 1993. Primarily focused on agriculture, corporate, and commercial transactions. Joining D'arcy and Deacon, Mr. Stewart's practice expanded to include more complex corporate and commercial transactions, with particular emphasis on agribusiness concerns. Mr. Stewart's practice includes acting for international grain companies, manufacturing corporations, integrated livestock corporations, and numerous offshore privately held organizations. Prior to law school, Mr. Stewart started a grain farm in Poplar Point, Manitoba, and worked in oil and gas exploration in the Canadian Arctic and offshore in South America. Subsequently, he formed Stewart Ag Services, which assisted in reorganizing and restructuring agriculture operations experiencing financial difficulties. Mr. Stewart and his wife live on the farm at Poplar Point, Manitoba. Samantha Leetold is an articling student of D'arcy and Deacon and is expected to be called to the bar in May of 2025. She graduated from the University of North Dakota School of Law and was a board member of several student organizations during her time there. Samantha has a keen interest in corporate and commercial transactions and agriculture matters and has worked very closely with John and Don in these areas. We will now turn it over to D'arcy and Deacon and just give you a reminder to please put in your questions as you think of them throughout the presentation. Thank you.
Thanks very much for the introduction, Tasha. My name is John Stewart, as Tasha's already mentioned, and I'm here with D'arcy and Deacon with my colleagues, Don Peary and Samantha. The webinar today is designed to provide a broad legal perspective on some of the issues affecting producers with respect to either the statutory or the commercial declarations that they're having to sign prior to delivery of grain across Western Canada. We're not intending today to provide detailed legal advice for any of the producers that are joining this webinar, and nor are we here to try and answer questions specific to an individual producer's problems. Neither will we be mentioning any of the declarations that are being produced by any of the grain companies. This is intended to be a general webinar only. Nevertheless, as you ask the questions in the chat box, we're more than prepared to answer any questions that you may have, sanitized to remove grain or elevator companies' names. Don, you're on this with us and have been involved from the very start. Perhaps you can lead us through the start of the legal insights that we put together.
Thank you very much, John, and thank you for the opportunity today. Just quickly looking through the chat, seeing all the various folks saying good morning and checking out the various locations. So this is a really great opportunity for our firm, and I thank you for it. Sam, if we can go to the first slide, please. So I don't intend to spend a lot of time on the background here. Tasha did a very good job explaining the background on CUSMA and the grain eligibility declarations. I'll briefly mention, obviously, the history of grain variety declarations dates back to around 2006, when the Canadian Wheat Board used grain variety declarations in Western Canada, mainly for export purposes. Quite correctly pointed out that the current iteration of grain eligibility declarations came about as a result of CUSMA, and the Canada Grain Act was amended in 2020 to comply with CUSMA. The stated purpose behind the eligibility declarations at the time was to be the protection of Canadian grain quality assurance system and allow for the oversight of grain delivered into Canada from the United States. The Canada Grain Commission allows grain companies to use statutory form or their own form, but as we'll see in a second, the Canada Grains Act does provide for basic requirements regarding grain eligibility declarations. If we can slide to the next slide. So as mentioned, grain producers are now required by the Canada Grains Act to once each crop year provide an eligibility declaration. That typically occurs prior to their first delivery into Canada Grain Commission licensed elevator systems. And as we said already, that's required by the amendment to the Canada Grain Act, section 83.1. We can slip to the next slide, please. What we did here is we just simply reproduced the Canada Grain Commission form that is provided, and it meets all the statutory elements under the Canada Grain Act. Everyone should be familiar with this one. It's very simple. It's titled, obviously, a declaration of eligibility for delivery of grain. There's some basic personal information or company information. And then the declaration, or the active part of the declaration, is that the producer solemnly declares the grain to be delivered is of a variety eligible for the kind of grain and class declared by me. And then it gives some notes in terms of the following seeds designated as grain for the purpose of the CGA. And the declaration is then made by the declarant, dated, obviously, and delivered once every crop year.
John, we'll turn to the next section on this, and Samantha, if you could please just expand the written part of the slide and eliminate the header for it, that'd be helpful. All of the people that are watching today can then focus on them. No, go back to the one we were on. There we are. Thank you. No. Next slide, please. There we are. Next slide. So once the CUSMA came into effect and they had gone ahead and amended the Canadian Grain Commission's requirements for this declaration, then what happened was the Grain Commission got together with the elevator line companies and agreed as a policy that they could either use separate declarations or they could actually use one declaration, provided, however, that they had specifically listed the two parts to the declaration in whichever form they were giving to the producer. And so the commercial terms of these declarations from the different companies that were involved would include additional information that we could go back, Sam, to the previous slide, would include additional information concerning crop inputs, other warranties concerning the grain crop that were being delivered. It may include indemnification in these commercial declarations of the grain company receiving the grain in order to confirm the producer's obligations to deliver exactly what was under the contract. And the declaration may go so far as to restate some of the representations found in that contract. An example of a combined contract is on our next slide. And in this slide, we see, if we could get rid of the header on that, please, Sam, and make the, thank you very much. We have Part A, a producer identification, quite specific. Part B is a declaration made pursuant to the Canadian Grain Act. This declaration is taken verbatim out of the Canadian Grain Commission requirement, and it says that I am the undersigned producer and solemnly declare that unless otherwise specified by me, the grain to be delivered or sold by me or on my behalf is of a variety eligible for the kind of grain and class declared by me in my dealings with the recipient of this declaration. And it's made and intended to apply to all deliveries of grain listed in this document. And they acknowledge and agree in Section 2, or Part 2 of Part B, that the following seeds designated as grain for the purposes of this Grain Act that require a declaration include barley, beans, buckwheat, canola, faba beans, flaxseed, lentils, mustard seed, oats, peas, rapeseed, rye, triticale, and wheat. And that essentially sums up the declaration that's required under CUSMA. This combined declaration then goes on to deal with Part C, which is the declaration required by the grain handling company. And we can go through these 1, 2, and 3. The first two are relatively straightforward. I am the undersigned producer and have or will enter into a contract with the grain buyer to deliver grain. And in the case of a corporation, has entered or will enter into a contract with the grain buyer to deliver the grain, and I am the authorized representative of that company. Paragraph 2, the grain delivered by me hereunder consists entirely of a variety of varieties registered for sale in Canada for varieties protected by the Plant Breeders' Rights Act, requiring such varieties to be procured from pedigreed seed, i.e. varieties protected after February 7th, 2015. The seed from which the grain and was produced was purchased as pedigreed seed or derived by me from a generation of seed I originally purchased as pedigreed seed. So this is all pursuant to the Plant Breeders' Rights Act. And there was a UPOV directive issued some time ago, making all of us comply as producers with the requirements under the Plant Breeders' Rights Act. In this example that we have on the screen, ladies and gentlemen, we then go on to warranties that the grain company is asking the producer to sign regarding pesticide application. And it says that in addition to the below representations and warranties, I hereby further represent and warrant that all grain deliveries made by me or on my behalf in accordance with the declaration have only been treated with crop production products and or with active ingredients registered for use in Canada in accordance with the Canadian label directions. For more information on Canadian label directions, contact the product registrant. That's quite a broad statement. As we all know, there have been issues regarding different crop protection products being brought back and forth across the border or being used strictly in accordance with the label for those products. This warranty that we have in front of us goes down to list some of the specific pesticides that they're limiting the use of under the terms of these commercial contracts. Glyphosate ammonia is listed, and understand that it's registered for use in Canada, but using it may result in residues not acceptable in certain export markets. I hereby represent and warrant that any and all deliveries of lentils made by me or on my behalf have not been treated with any crop production product containing glyphosate ammonia, including but not limited to the product known as AgriCity Empower Good Harvest. Going down below that, we then have chlormequat. And if I could just get that scroll down, please, Samantha. Chlormequat. I understand that chlormequat is registered for use in Canada, but that using it may result in residues that are not acceptable for certain export markets. I hereby represent and warrant that any and all deliveries of barley made by me or on my behalf have not been treated with any product containing chlormequat, including the product known as manipulator. Go to the last part of the declaration in the example that we're using at the top, and I won't go on just reading this ad nauseum. They talk about fluropyram and they talk about sethoxidum, and they're listing the crops that are not permitted to have these in it. The concern that you'd have as you look at these and as we're signing this combined declaration is that there may very well be in the hands of some producers some grain in their operation that has in fact been treated by these products and wouldn't be applicable, wouldn't be permitted rather to be delivered under this contract that they're signing. The contract goes on down below to read that the contract at paragraph 4, if we could scroll down, please, Sam, is intended to apply to all deliveries of grain made by me or on my behalf to the grain handling company for the 22-23 crop year. And that part C of this declaration applies to the following grains, and then it lists out again ad nauseum all of the grain that was listed in the start of this. So we see the dilemma that we have if we're presented with such a declaration as this, when it's going to be used for all of your deliveries, and yet of itself may not necessarily be applicable to all the grain the producer has on hand. Going to the next slide, Section 83.3 of the Canadian Grain Act provides that no person shall knowingly make a false or misleading statement in a declaration referred to in Section 83.1, which is the declaration that Don pointed out previously is required under CUSMA, and that these false declarations attract penalties under the Canadian Grains Act. Next slide, please.
So I'll jump back in here, and thanks very much, John, for walking us through the combined declaration there. So we're just going to briefly touch on the legal implications of combined declarations. And so, obviously we've highlighted the first one, which is, what happens if you have a declaration or delivery of grain that may be false in light of the declaration that's presented to you. Something in that combined declaration is not something that you can comply with. Obviously, that may first of all lead to the grain not being accepted for delivery in satisfaction of your contract. So you have a contract to deliver a certain type of grain, and under that contract, it states that certain inputs will not be used, or crop protection products won't be used. If you can't deliver that declaration at the time of delivery, the grain company is entitled to say you have not met your contractual requirements. We'll come back to the consequences of that a little bit below. False declarations may also lead to contractual rights of action. So this is a circumstance where you make not an accurate declaration, but a false one, and provide the grain anyways. In that case, a grain company that suffers damages or somewhere in the chain may be looking to claim those damages, those expenses, those costs back against the producer who filed that false declaration. Briefly, we'll touch on an indemnification. Most grain contracts that I've reviewed, and in fact that combined declaration specifically state that there's an indemnification, meaning a hold harmless clause, whereby if the grain company suffers any damages as a result of a false declaration or an inaccurate declaration, they're by contract going to claim against the producer to make the grain company whole for those damages suffered. That's an indemnification. And so that's slightly different than damages itself. It's a circumstance where, for example, a shipping company would end up suing the grain company for as a result of a delivery that doesn't comply with the declaration that was made. The grain company would then be looking to take those claims, put them against the producer, and ask for indemnification or to be made whole by that producer. Briefly, we'll talk about the different heads of damages that can arise under a contract. So the first is what we call direct or incidental damages. These are damages that are directly related to the contract. So you contract for the delivery of a certain quantity of grain. You can't deliver it. The grain company has to then source that somewhere else. their damages are the differential in cost and expenses that they're incurred as a result of having to source that from a different market. Consequential damages, those are damages that are what are believed to be reasonably foreseeable. So it's a little bit different than direct damages. Now it's a case of damages that aren't simply, you know, a differential in cost, but maybe the time incurred in relation to resourcing that product, expenses that are maybe perhaps legal expenses in enforcing the contract, things of that nature.
Just to add to that, Don,
Yeah.
one of the consequential damages, of course, would be the end user.
Yes.
If the end user has contracted with the grain company to go ahead and source the grain that they need for a particular use, and the grain company delivers to the end user grain that doesn't meet those specific requirements, then the end user will claim against the grain company, and the grain company then has the right to claim those consequential damages back against the producer itself, who violated the contract by delivering the grain not in accordance with the declaration as required. Go ahead, Don. Sorry to interrupt.
Not at all. Briefly, we'll touch on the last aspect, which is a lot of grain contracts or any contract in general will often provide for what are called liquidated damages. And that's a circumstance where the grain company and the producer are agreeing by contract upfront that in the event a certain term of the contract is breached, we're going to agree upfront that the damages are going to be what we consider to be liquidated damages. We'll specify either how that's calculated or what the number is. A good example of that is if a contract provides for delivery by a certain date, every day that the delivery is delayed, it may state in the contract that there's liquidated damages of, for example, $100 a day until such time as that delivery has been achieved. The purpose behind it being, we're not going to argue later on about what the damages actually are. We're just going to say up front that we agree this is what the liquidated damages will be. And it just is intended to make for an easier, more upfront discussion of potential damages under the contract. Not mentioned on this slide, and John probably will want to jump in on this one too, but I'll just briefly mention as well. Damages under a contract, you know, if a party to a contract suffers damages, they do have what's called the duty to mitigate their damages. And the point behind that is that, you know, if you are in a contractual relationship and the other party is in breach, you don't obtain the right to just simply sit there and allow the damages clock to run. You have a duty to take steps to reduce your damages within a commercially reasonable context. You don't have to, you know, expend all efforts and whatever. But you do have a duty to not just simply let damages and accumulate in an unreasonable fashion. And that's called the duty to mitigate damages.
And that's exactly right, Don. When producers are unable to deliver exactly what is required under a contract, either a volume or quality, immediately they have to notify the grain company of that inability to deliver. And immediately upon them notifying the grain company, preferably in writing from your lawyer's perspective, then the grain company automatically acquires the duty to mitigate the losses and take steps to fulfill the contract as quickly as they can and as reasonably as they can in order to minimize their exposure from either end users, costs, demurrage of a ship, or other incidental damages that they may incur. So it's important for all of us to remember as producers that in the event that we're unable to fulfill a contract strictly in accordance with its terms, we have a duty to tell the grain company immediately, and the grain company then picks up the duty to mitigate those losses, if any. Thanks, Don. So going to the next slide. So combined declarations are probably more and more common all the time. It has to be clear under the legislation that both declarations are included, and the declarations should be set out separately inside of the 1 or 2 page document itself. Terms in the combined declaration that go beyond the CGC's prescribed form are still legally binding, and producers are still liable for any breaches, whether it's intentional or unintentional. And as I said earlier in this presentation, if we've signed one of these combined declarations covering the waterfront on a variety of crop protection units, and then deliver a product that we have sitting in the bin from years previous that actually has been treated, even though we were unintentionally delivering grain into that contract pursuant to this declaration, the producer may be held liable for that. So producers should check these delivery declaration provisions very carefully and be aware of company-specific terms before signing the grain contract. In a perfect world, all of us at the start of the crop year would sit down with the grain company, sign our CGC declaration, which we're going to have to sign anyway, and then sign the specific commercial declarations in lockstep with whatever contract we happen to be signing with that company. Going on to the next slide, I think we've essentially covered the waterfront. And should there be questions at this point, Tasha will turn this back over to you.
Thank you so much for that presentation. I have a few questions coming in that we will discuss. The first question I see is, what am I liable to as a producer? I have grain from a previous growing season that may now violate the joint declaration or commercial declaration in the current growing season when selling.
Well, the answer to that is quite straightforward, Tasha. We can't deliver that grain under that contract. The producer should immediately contact the grain company and explain the situation as it is and see whether or not the grain company has a market for the grain in question. The grain may very well have to be sold into the feed market. For instance, if it was barley or wheat that was undeliverable pursuant to a specific contract, it may end up that the producer has to contact a feed company and see whether or not they have an opportunity to purchase. What the producer cannot do is deliver it with this declaration under that contract. If they do so, they will face liability for having done what they shouldn't have done.
Thank you for clarifying that. We have another question that's come in. What are my options for recourse if I feel that a joint declaration terms are unclear, or if I wish to sign the two that can be done in this situation?
If you like, I'll jump in on that one, John. The CGC has made clear that CGC licensed facilities are to have the statutory declaration available for signature. And so if a producer is feeling that the joint declaration terms are unclear, or if they're not being presented with the Canada Grain Act statutory declaration, they have the right to ask for that, and either compare that to the joint declaration to make sure that those statutory elements are being met, or to sign them separately. With respect to the aspect of what if I feel like if the joint declaration terms are unclear, if you feel the terms are unclear, the only advice I can give is to seek advice, seek clarification. Obviously, these contracts are for significant amounts of money. You don't want to be signing something with a nagging doubt in the back of your mind, and so speak to the grain company, speak to your legal counsel, speak to whoever you can. Have reference to the original grain contract that you signed to determine whether or not the terms of that joint declaration are supported by that original grain contract, and if not, seek clarification.
That's right, Don. And I mean, and that goes back to our previous comment that I think one of the difficulties that producers have is by not signing the declarations ahead of time. You show up with the Super Bee at the elevator, you pull up to the probing station, somebody runs out and says, hey, John, you forgot to sign these declarations, go ahead and sign this. I just take a look down and say, well, I'm embarrassing myself. I got a whole bunch of guys behind me. I'll just go ahead and sign it anyway. That's not what you should be doing. We should be sitting down and getting these declarations looked after at a time when we have the ability to either compare the commercial terms that we have in our contracts with the commercial terms in this joint declaration, and we should be reasonably familiar with the CGC declaration and be able to recognize it in which section of these combined declarations that we're signing ahead of time. As Don said ahead of time, if it's unclear, don't sign it. If there's a question regarding the CGC portion of it, if you think it doesn't comply, refuse to sign it and contact the CGC. Get clarification of these things in every instance before you sign them and before you do something like deliver grain against the declaration that you've already made.
Well, you guys answered that question so well. I think you've covered the next question, but I'll still read it, but I'm pretty sure you covered it pretty well there. Because the next one was, what can producers do if a company refuses to provide separate declarations? John, I think you kind of tackled that when you mentioned contacting the CGC.
100%. It would be unusual in my mind that a grain company wouldn't be able to provide that sole declaration as required by the CGC. I would be really concerned if one of the elevator companies that we were delivering to would refuse to produce the solitary declaration that I could be used to compare with the terms and conditions in a combined declaration. And as I say, for the record, that would be, to me, extremely unusual. And I'm not aware of any elevator company that would do that to us. If they did, don't sign it.
Perfect. Thank you. We have a few more questions rolling in, which is good to see. The next one is, do you have any thoughts or considerations related to the timing of signing the joint declarations? The contract grain now ahead of the growing season. What are your thoughts on that one?
Go ahead, Don.
Yeah, so I mean, it's an interesting timing concern. Bear in mind the statutory requirement is that once every crop year, a producer is required to provide the eligibility declaration. So there's no reason, for example, that a producer couldn't sign the CGC declaration on its own early, and then on the commercial one, you know, it to the extent that your grain contract provides for specific terms and conditions concerning protection inputs, you know, it would be a great idea for the producer to ask to see what the declaration on delivery is going to look like. You know, at this point, the procedure has been around for enough years. It shouldn't be a big deal for the grain company to provide what that declaration is going to look like on delivery. And so the producer can satisfy themselves, that they've got the CGC declaration done early, and then the commercial declaration, you know, that should be, you know, to the extent possible, reviewed at the time of the contract being signed.
Great, thank you for clarifying that. We'll move on to the next one. This is as well. Do you have any examples of how the CGC handled past instances of producers making a false declaration by mistake?
That's a great question. Unfortunately, the answer is no. We don't have any examples of how they've handled previous in past instances, rather, of producers making false declarations. We're aware tangentially of situations that have unfolded across Western Canada. Deliveries of grain weren't in keeping with the strict terms of the contract. Some of it was specifically under the plant breeders' rights. But as far as how the CGC handled it, that would be a private matter between the CGC and the producer. And certainly, to the best of my knowledge, I am not aware of any publication trying to explain exactly what the CGC has done. And it may, in fact, breach some privacy laws should they decide to disclose that arbitrarily in public.
That makes sense. Thank you for your answer. This next question, under the clean fuel regulations, it is a requirement to identify where the fuel crop was grown. Canada I believe it is down to 1 point, likely the farmyard, but to comply with possible export to USA, they may require more detailed information where the fuel crop was grown. How is this enforceable? And is it the grain buyer that must add these additional details in the declaration?
I'd like to say this. Could you repeat the question?
Yes, sorry, it's a little lengthy. I think it's kind of
Yep.
referring to a newer issue to do with the clean
Go
fuel.
ahead.
So under the clean fuel regulations, it is requirement to identify where the fuel crop was grown. That's
Okay.
the statement. In Canada, I believe it's down to 1 point, which is likely the farmyard, but to comply with possible export to USA, they may require more detailed information where the fuel crop was grown.
Correct.
This enforceable, and is it the grain buyer that must add these additional details in the declaration?
Well, if they're going to start taking on declarations such as that, you're correct. They're going to have to be much more specific. Grain farms across all of North America are no longer a quarter of section, which includes my house. And so as the farms expand and may cross jurisdictional borders between Saskatchewan and Manitoba, Saskatchewan and Alberta, Alberta and British Columbia, those type of requirements for the specific location of where the grain was produced would have to be set out in detail by the grain company. And similarly, the producer would then have to go ahead and make sure that any declarations that they're going to make under that are going to be strictly in accordance with what it is they're saying. Now that we have our seeded acreage reports being filed with all of our provincial crop insurance providers, the producer has the ability to understand exactly where the grain came from. And similarly, with their harvested production reports that we file every year in the fall post-harvest, we know what grain was produced from what fields. To the extent that we're able to make sure that that grain hasn't been commingled in our own grain facilities on our farm or in the grain facilities that we're sending it to, that's a whole different issue. But all of that detail has to be clearly understood and set out in a declaration prior to the producer delivering under a contract like that to a grain company that requires that type of specific information.
Thank you for that answer. I'm also going to make note that our policy and market staff, Alberta Grains, Shannon Sarita, has an article regarding this, and maybe it's possible we can link that in the chat. Throw that out there.
Can't hear you.
Oh, sorry. I said our policy and market staff, Shannon Sarita, has done an article regarding the fuel, this regulation. Just wondered if one of our staff could maybe include that on the chat for producers for wanting a little more background.
Yeah.
Oh, they're saying my connection's poor.
Correct. Yeah.
That's rural internet.
Yes.
Are you able to hear me any better?
When you speak closer to the microphone, yes. As you move back from the microphone, it becomes almost silent.
Okay, I will try to stay near my microphone. The next question is, how are financial damages determined if a producer fails to fulfill the contract?
Well, so grain companies don't work in isolation. They have an end user that they want to go ahead and provide this product to. And that product is usually ending up in either a rail car or a ship. And to the extent that the producer is unable to deliver on time, and they delay the ability to fill either that grain train or that ship, those grain companies will incur demurrage costs as a result of making somebody sit and wait for the producer to fulfill the contract. If they can't, and the grain company has to go out and source grain from other people, similarly, those people are going to need a little bit of time to get that in. All of those cash costs, all of them, can be held against the producer who's failed to deliver under the contract and cause the grain company to incur those losses.
Thank you for that. The next question Does combining the declaration limit my ability to negotiate a term for the commercial portion of the declaration?
Go ahead, Don.
Yeah, so I mean, to the answer to that is no. You know, there's you always have the ability to limit or to sorry to negotiate the terms of your contract. That's just in general terms. In practical terms, you know, the declarations and in the grain contract will provide for specific terms and conditions, as John's already mentioned. The grain companies are purchasing the grain with an end user in mind, and that will, to a large extent, determine what terms are going to make it into the contract. Timing of delivery, protection inputs, all those types of things will become important terms of the contract. So combining the declarations, it's not intended as a tool to squeeze the negotiation of the contract. In fact, the contract should be negotiated before the declaration is presented for signature, and both should be reviewed at the same time.
Great, thank you for clarifying that. Another question we received: where can we get a copy of the statutory declaration required by TC?
Well, we presented it in one of our slides earlier on this morning. I believe, Don, and you can correct me if I'm wrong, it's part of the regulations set out in the Canadian Grain Commission. And I think if you go onto their website and go down to the regulations section, Sam, you can tell us whether that's true or not. You can find an actual copy of the Canadian Grain Commission statutory declaration. But I believe the producers can do this all online.
Yes, yeah, I can attach the declaration in the chat, and then also if you just Googled Canada Grain Commission declaration, it should be one of the first options.
Right.
But I'll include it in the chat anyways if people want it there as well.
Perfect.
Thank you so much, Sam. Another question: what are our obligations to sign the latest ISCC, a self-declaration, self-assessment? This is being requested to sign by all producers delivering to Richardson, sorry, delivering in Alberta. I'm not gonna, sorry, I didn't mean to mention names. It seems there is a lot of information required that feels quite invasive. Now, my guess is I believe this is probably also talking more of between farms regulation, but I'm not positive.
For the life of me, I heard about a quarter of that. So I'm not sure if I'm the only one on this webinar that's having this difficulty. I'm old, and so who knows? Could you mind repeating the question?
I definitely think it's my internet in Northern Alberta that might be the issue. I will try again. What are our obligations to sign the latest ISCC EY self-declaration, self-assessment? This is being requested to be signed by all producers delivering to a particular elevator here in Alberta.
Can you spell us the acronym, please? IS, I need to know what that is.
It's ISCC, and then it's EY.
So, folks, if I can jump in here for a second, I'll admit I'm not familiar with this in great detail, other than I'm aware of it. This is the International Sustainability and Carbon Certification and the self-declaration, self-assessment. You know, without giving it too much research, and something might be a jumping off point for me. I always go back to what are the terms of the contract. If the terms of the contract provide that you will, as a producer, provide this self-assessment or self-declaration to Richardson Pioneer on or before the time of delivery, then that's a term of your contract. I don't, as I quickly review this, I don't see this as a legal requirement so much as it's a contractual requirement. And so, yeah, I have no doubt that the information required is quite invasive, as just briefly looking at their website here. But again, I would defer back to the terms of the contract. If your contract at the time of signing says you will provide this, then that's a term of your contract.
Right. And so your obligations are, if you fail to deliver grain that qualifies under this carbon declaration, then that failure to provide that may result in liabilities of the grain company to the end user, which may result in costs, and those costs will be revisited upon you at whatever grain company it is discretion.
Thank you. That is a good answer, and that makes sense that it ties back to that original contract. So thank you for clarifying that. We've got a couple more questions, and it looks like we have time, so we'll tackle them. Are there other things farmers could be held accountable for in a contract with a grain company beyond quality factors and potential chemistries used?
Well, you can be held liable for delayed delivery. You can be held liable for failure to meet grade. You can't deliver a feed wheat against a number one wheat contract. We can have issues regarding mold. We can have issues regarding fungus. We can have issues regarding impurities or contaminations. There's a long list of the reasons why grain doesn't fit the intended use of the end user. And to the extent that those are clear, then liability coming from it. As Don said earlier, you have to look to the contract to find out what that may be. But certainly timing, volume, moisture content, and grade are standard forms in contract requirements.
Thank you. And I think that's a good reminder for us producers to be looking at these contracts we're signing.
Right.
Like, I think it's just a great reminder to pay closer attention.
Absolutely. Fusarium head blight, as all of us on this webinar know, have been the bane of the milling industry for the better part now of almost some 20 years after it made a resurgence in the late 1990s. You get a quality of grain that is infected with Fusarium head blight. It's not going to meet the specifications set out in a miller's contract. So it becomes a problem for them, regardless of what's been sprayed on it.
That's right. Thank you. We have one more question I see here. I've seen some different variations of joint declarations from the different companies. We be pushing for a standardized joint declaration from the CGCs and grain companies. Like, I guess they're just wanting to know if we should have it standardized between companies.
Yeah, I mean, I'll let Don weigh in on this as well. Grain companies are entitled to make the contract that they want to make for the quality of a product that they wish to purchase. And it's certainly not beholden upon any grain company to follow the lead of anybody else. The details set out in these contracts are as variable as the buyers may have from the people that they're trying to procure the grain on behalf of. So yeah, there is no obligation to try and get these things standardized at all. Go ahead, Don. Don is now silent.
Turn that off. I apologize. That's exactly right, John. The only concern I would raise with respect to a joint declaration, you would need the cooperation of the various grain companies. I don't know to what extent there's any sensitivity in terms of competitive or any sort of proprietary information that the grain companies would see as part of their contractual negotiations. I mean, I think it would be a great idea if and good for producers, whether or not you could have uniformity across the board with the grain companies, who likely all have a common interest. They just may not have a common interest in accommodating standardized joint declaration. I suspect any movement in that regard would require legislative action more than anything else. I just simply don't see the incentive for the grain companies.
And further to that, what Don is saying is one of the concerns that we have here is that grain companies start using some of the product information that is being questioned by the Plant Products Division ahead of it becoming statutorily required. There was discussion here about a year and a half ago regarding lambda insecticides, and that it wasn't going to be permitted to be used. And yet at the same time, producers had purchased these. An example of that on the trade name would be Silencer, and had purchased them and had them in storage. And so once you bought them, well, you're going to be using them. If they're going to go ahead and make this inapplicable to production of some grain crops, then they should be telling us that ahead of time so the producer isn't put into the predicament of having used something that may or may not be prohibited from being delivered into the system in which they've made a declaration. So we're hoping for better clarity from some of our regulators to make sure that we know ahead of time some of the issues that are arising with some of these crop protection products.
Thank you for that. That would be very helpful, John, if we knew further ahead. Would be very useful. I had another question come in, and we have time, so we're going to tackle it. How can a producer protect the integrity of the sample of grain being delivered? Most places now probe the truck, examine and grade the grain in a location unseen by the producer. The sampling equipment appears to be questionable with respect to guaranteed purity between grain lots. It seems to be a problem with the system.
Yeah, that's a common complaint that we've heard all across Western Canada for quite some time now. Grain probes are mechanical. They go in and they do what they do the way they do it when they do it. It's incumbent upon producers, of course, to keep samples of what it is that they're delivering. And if there's going to be a dispute, the Canadian Grain Commission has an ability to go in and get involved in the decision regarding that dispute. All producers, as they're loading their own grain facilities, know enough to take samples of what it is they're producing and keep those segregated as to the bins, as to the fields if necessary, and as to the truckloads that are going on. The better job the producer can do of keeping evidence handy, particularized to either truckloads or contract loads, or however the producer can best evidence or can best keep that evidence, rather, the more successful they'll be if there's a dispute between what the sampler has told them the delivery was and what was actually delivered into the crop. But it's the nature of disputes, ladies and gentlemen. And the more evidence you have to support your position, the better off you're going to be.
Thank you for that. That was a really good refresher for producers and what we can do to protect ourselves with information. It looks like at this point we have tackled all the questions. I can I'll maybe just give a quick final call out for questions, but we've had quite a few. But before I close out the session today, I would like to offer D'arcy and Dee to give their final thoughts.
Well, the issues that the Alberta Grains has put forward are huge issues in the minds of producers all across Western Canada. And thanks to Alberta Grains for having this webinar to better explain this. Producers have to be diligent in making sure that what they're doing with their contracts and with their grain declarations are given the type of attention that they require. It's a huge part of our business now. It's no longer what we used to do back in the 60s, delivering grain into a Canadian wheat board contract or delivering it across the board to a feed company. The money involved, the volumes involved, and the detail involved are getting bigger and bigger and more complex every day. And producers have to start spending the time and attention necessary to do a good job on this. We can be the best producers in the world, screw up some of these declarations, screw up some of our deliveries, or mistakenly apply products that are no longer permitted and suffer the consequences of that, which will have very severe consequences to our operation as a whole.
Dawn, do you have any thoughts you'd like to add?
I echo John's comments. The size and complexity of the industry, it's although there's always a constant sort of move towards quicker signing of contracts, DocuSign over the phone, things of that nature. Just get it done, get it done. The nature of the product that you're delivering, the costs involved, the potential liability now that products make their way into a global market. It from our perspective, from the legal perspective, it requires a little bit more diligence, a little bit more thought, perhaps slowing down, reviewing, and making sure that there's a clear understanding in your mind of what your contractual requirements are, and can you deliver upon them. The only point I'll reiterate, because John makes a good one, we look at these oftentimes in the context of disputes, and with any type of dispute, the party that has the better, more contemporaneous, more fulsome evidence will typically win their dispute, in a court of law or any other tribunal. So, to the extent that you need to mitigate your damages, do it in writing, or to the extent you need to notify a grain company of any failures, do it in writing. Keep your contemporaneous samples of what you're delivering. All those things takes time at the time that you probably don't want to spend it, but you won't regret it later on down the line in the face of a dispute.
100%.
Thank you. That was some great final thoughts. Today has been very helpful for all of you who tuned in. I'm sure I got a lot out of it. I sincerely want to thank all our participants for joining us today, and especially want to thank our guests from D'arcy and Deacon, Don, John, and Samantha. Very much appreciated your advice and help on this today. Also want to thank our partners from SaskWheat, SaskBarley, and APAS. It was great to team up and get some information out to our producers. The webinar today has been recorded, and it'll be posted and shared again through our partner organizations through the various channels. So please stay tuned or share with others that maybe weren't able to tune in today. If you have any follow-up questions or are looking for additional resources, please reach out to one of our organizations or visit the Canadian Grain Commission website, which also has a number of resources listed on there, for example, like the one Samantha put in our chat. With that, I'd like to thank you all for your active participation and questions that brought good discussion and taking time to join us today. And I want to wish everyone a successful 2025 growing season. Thank you.
Thank you for the opportunity.
Thanks very much, ladies and gentlemen.
Great job, everybody. We're just waiting for